Good morning. I have not read any of the discovery motion that Puritini, Blue Bacon, has filed against Decastro and Decastro versus Peter. But I can tell you how it's going to shake out. Unless Decastro makes a complete ass out of himself in his response, the way it's going to work out is the court is just going to say, bro, answer the questions. The court's not going to award sanctions. The odds of the court awarding sanctions are incredibly low. I'd say less than a 10% chance. The odds of those sanctions being anything other than nominal damages, or not nominal damages, but nominal sanctions, like 2, 3, 4, under $1,000. The odds of them being over $1,000 is probably about 1%. I mean, it's very rare. It's probably not going to happen, and the court's going to give a lot of leeway to a pro per litigant, unless Chile makes a complete ass out of himself in responding. The objections that I have read, because snippets have been posted in my Discord. The whole motions have been posted in my Discord, but I loathe discovery. But the snippets that have been posted in my Discord about questions and responses, Chile is not giving good faith objections. His objections lack merit. But on the other hand, the court... I have found that there's a great reluctance of courts into getting into the weeds into these things. They're not going to go through each question. This is a law in motion. This is going to be a 15-minute hearing, or thereabouts. It's not intended to go line by line, number by number. If the court is feeling really rambunctious and full of energy, the court may state which numbers that Chile has to answer. But considering the voluminous amounts of interrogatories and requests for admissions and things that Chile did not answer or answered solely by objection, the court's probably not going to do that. If there was like one or two questions that the parties couldn't agree on whether or not Chile had an obligation to answer, the court would probably give individual, like if there's two of them, the court say, yes, you have to answer number 13, but no, you don't have to answer number 48. But in this case, the court is just going to say, Chile, you don't know what you're doing. You're a pro per. So here, let me help you out. You have to answer. So I'm going to give you 45 days from today's date to answer these questions in their entirety. And I'm going to deny the motion for sanctions. And you have to appear for deposition, and this and that and the other thing. That's just the way I see it playing out. California doesn't have the disclosure requirements that federal courts do. In federal court, you have to go in, you have to lay all your cards on the table, and then only if the opposition thinks that there are cards that you haven't presented, then they could ask you, hey, show me this, show me this, show me this. That's how discovery works in the federal. In California, you have to ask for everything. You have form interrogatories, which will catch most of the things you want to ask about. And all you have to do as the person asking those is just check boxes. There's just a series of boxes to check. Form interrogatories general would be what they're probably using. Again, I haven't looked at any of their discovery other than what's been posted. Then you have special interrogatories. Technically, you're limited to, I think, 35 or 45. I don't remember which. Special interrogatories. That's where you could ask questions that are more specific to your case. You could always ask more, as long as all you have to do is write a declaration saying that you're familiar with it. It's in the statute. That's literally. You just copy and paste what's in the statute and you fill in a couple blanks. And then you could ask as many as you need to. And the only way that the person who has to respond to it can stop you from doing that is by filing a motion for a protective order. And most cases use way more than the 35, I think. I think it's 35 special interrogatories. Then there's requests for admission. Again, you're limited to a like 35 of those, but again, all you have to do is have a declaration. You could ask more. And then there's requests for production / inspection. So those are unlimited. The wording of those can be a little more It's a little more lax. You could have conjunctions in those without, they can't object to compound on those. So anyway, and those are unlimited. So California has a very open stance on evidence. They want everybody to have their cards on the table. I mean, that's what litigation's all about. I know a lot of attorneys don't understand that, but attorneys that are billing by the hour, like defense attorneys, they love to muddy the water and give crap answers and push everything all the way up to the point of potentially having discovery motions. But it's just a money sink for the client, really. It's just a way for the attorney to make money, I think, or they're incompetent. I mean, one of the two. Maybe a little column A, a little column B. I don't particularly like to do that. I narrowly tailor my questions to actually ask about what the relevant elements of the particular situation are. I answer as openly and forthrightly as my client will allow me to answer. And I try to avoid discovery motions because there's several hundreds of pages. They were talking about just a separate statement. A separate statement, by the way, is you have to take each question that you have a complaint about the answer on. You have to take each answer. You have to take what you asked, what you set forth in your good faith meet and confer letter, how they responded, plus any subsequent responses. You have to take all that for each question that you don't think they answered right, and you have to put it into what's called a separate statement. So your separate statement is probably about 4 times as long as all of your discovery combined. It's stupid, it's time consuming, and 9 times out of 10 judges don't even look at it. At least it doesn't appear that way from my side of the bench. So, long story short, unless Chili is a complete dick when he responds, and maybe even if he is a dick when he responds to their discovery motion, it's still just going to be the court telling him, go ahead and answer. It's very unlikely he's going to get sanctioned. Even if he is sanctioned, it's not like they're going to collect on anything. I mean, what are they going to do? File an abstract to try to execute on what? I mean, he's judgment proof. He gets an order to pay them attorney's fees, and then what? And then what? Nothing. That's what. So, I mean, everybody's getting their panties all rolled up in a bunch thinking about this. It's a big nothing burger. The judge is going to order him. The judge is going to say you have 45 days or whatever to respond to all this stuff. And Chili's probably not going to respond adequately. The attorney is probably going to do another good faith meet and confer attempt. Chili's probably going to botch that response. The attorney's going to file another motion, and he's probably going to seek evidentiary sanctions. So in that seeking evidentiary sanctions, he's going to say, look, I've asked already once for a motion to compel. I'm asking for another one, but what I'm asking for is to have these particular admissions deemed admitted against Decastro. Whatever way, admitted or denied, whichever way they would be construed against Decastro. That would probably be the next step. I want these interrogatories construed against Decastro. I want Decastro precluded from producing any evidence at trial about this issue. Like say, for example, Decastro has alleged that Piratini has, defamed him. And if Piratini asks, produce all the evidence that you have about my defamation, me defaming you, in not so many words, phrased appropriately, and Decastro refuses to produce that, then the evidentiary sanction would be, motion to compel, and I also want it to be him to be precluded from introducing any evidence at trial about my defamation because he wouldn't show me what I allegedly did. But that would be a second motion. That's not going to be on the first motion. This one, it's just part of the drama, part of the show. Nothing to see here. Move along, folks. Thanks for watching. Have a nice day.